Okay, so we're back. I'm not going to bother with a huge amount of introduction, but this is where we got to last time, and hopefully you'll have seen that in the comments I've linked off to both Al Yamamah, not comments, in the notes, I've linked off to Al Yamamah's a fantastic article from Tufts, and also to the webpage from the CPS. I got kind of sucked down that bunny hole there, sorry about that, but hey-ho, let's move on. What I've got in here is a very, very quick summary of the problems that we have with judicial review. And to a certain extent, we've dealt with both of these elsewhere. Are they trying to usurp government's policy sovereignty? No, they're not. They're trying to force government to operate within a reasonable legal framework. That is the job of that is the job of the courts. Just as with our deputy head, he's not trying to rewrite the school rules, he's just making sure the school rules are properly applied. And that's exactly the same here. When the judicial review is applied to Parliament, they're not telling Parliament that they should or should not pass these laws. What they're doing is the courts are saying, look, you committed to upholding EU law, and you committed to upholding the ECH, the European, the Human Rights Act, and this legislation is not doing that, and we're only forcing you really to uphold your own laws. The problem is this, in that if we're looking at whether or not a law has been properly applied, I did say earlier that it was an objective or a positive statement. Ideally it would be, but sometimes it's not. Sometimes we'll get a case where it's hard to tell whether it is. Or we looked at it from that direction. If we look at it from that direction, it looks a bit dodgy. If we look at it from the other direction, it looks sound. Now, that is pulling the court into politics. The further we get from objective statements about whether or not this law was upheld or whether or not this law was respected, the closer we get into politics. And our courts in the United Kingdom are determined to avoid being sucked down that particular bunny hole. And here we can draw a significant contrast with the work of SCOTUS, the Supreme Court of the United States, where we have an overtly political judiciary. I don't want to go down that, but we will come back to this later. We'll come back to this idea of politicization of the judiciary. And the key thing to remember there is the benefit of the doubt. The benefit of the doubt is just one of those things that we come across in the in law, and this is from America. This is from SCOTUS. The settled law, according to Justice Holmes, or the settled rule, is that if there are two possible interpretations of a statute, if you look at a statute from this direction, then it looks valid. If we look at it from the other direction, it looks unconstitutional. If that's the case, then the benefit of the doubt should accrue to those who have legitimate democratic legitimacy. So this is when the Supreme Court says, well, we can look at it this way or we can look at it that way. So both of those positions are valid. In those instances, who's voted for the judiciary? Nobody. So in that case, the benefit of the doubt should accrue to anybody who has democratic legitimacy. That is just a general principle that the Americans have adopted, or at least they've cited here. And it's very, very important because Roberts uses this in upholding Sebelius. You may or may not have got to this point yet. This is the case that saved Obamacare. And in the case that saved Obamacare, the court was split 50-50, with Roberts the last person essentially to vote. And everyone expected him to vote along with the conservatives. But on this occasion, he said, actually, no, there is an element here of constructive ambiguity. I am going to side with the guys who have been voted. I'm going to side with the people who have actually got some degree of democratic legitimacy rather than use my own opinion to establish what law is. Because remember, nobody gets to vote for judges. So where it's a matter of opinion, you want to be voting for them. If it's a matter of expertise, then perhaps you're more prepared to leave it to the experts. This is where we see the benefit of the doubt accruing to the democratic, and this applies to the UK as much as it does to the United States. And the proof of the pudding is in the numbers. The proof of the pudding is also in the Human Rights Act, which puts upon the judiciary an obligation to try to save legislation rather than to recklessly reject it. So, in terms of judicial review and policy sovereignty, as I said, this is all about the rules of law and the rules of natural justice. The government has to abide by the law. There is no doubt there. They cannot act in a way that is illegal, and the law has to be applied consistently. And we can see that in Brexit. I'm not going to go through this in a whole lot of detail. The key point is that Britain got into Brexit by the EU law. So when the government said that it wanted to trigger Article 50 by itself, the court said, no, you can't do that. Now, this is not a value call. This was a simple fact of law. If you get into something by law, then you have to get out of it by law. So Parliament could authorise the government to trigger Article 50, but it had yet to do so. And so the courts said, quite rightly, that well, you can read that. It's a beautiful piece of legalese there from Lord Neuberger, and a masterpiece, really, of making a good case clearly. Now, we talked about the way that the judges in the UK try to avoid appearing political. I think it's fairly clear to any sentient person that this was not a value-based judgment. This was not about politics. This was simply about law. The law says we are going into the EU in 1972. If Parliament giveth, only Parliament can taketh away. And so the government did not have the authority, the legal authority. It might have had the political authority after the Brexit referendum, but it did not have the legal authority to trigger Article 50. Parliament could, and Parliament indeed did. Parliament then passed the law that gave the government the right to trigger Article 50. But even then, even though this was quite clearly a legal decision, an objective or positive legal decision, the judges had to deal with this. And this is one of the reasons why judges try to avoid politicization as far as possible, because inevitably when they make a decision, someone's going to disagree with it. And they want to make sure that if someone's disagreeing with their decision, that they're disagreeing with it on a legal basis, not on a political basis, because judges don't want to get drawn into politics. This is what the Kilmuir rules were all about. I'll link off to those in the thing as well. Judges don't want to get involved in politics because that's not their job. They are the custodians or the guardians of the law. They are not the people who write the law. The people who write the law are the politicians. And the politicians who write the law should be held democratically accountable. The judges sit as independent and neutral arbiters or guardians or custodians of the law that is created by our democratic institutions. And I will stop there. In terms of and this is really what I was talking about. Parliament is the legal sovereign, so Parliament can't essentially break its own laws except these two. And Parliament has said that it is going to abide by these laws, and it has said to the courts, when we break these laws, when our laws are inconsistent, either with the Human Rights Act or with EU legislation, then it's your job to tell us. And that's what happens. Now, this is a rather obtuse bit of legislation. It's just in there because I happened to be there the first time I did this presentation. I've got no idea what the Job Seekers Back to Work scheme is about, and I hope never to find out, because I kind of enjoy my job and I like the fact that my children can eat from time to time. However, when the Job Seekers Back to Work Schemes Act was passed, it was then challenged in the courts by individuals who suffered under it, and quite evidently they did suffer under it. And the courts looked at it and they said, look, this is not consistent with the Human Rights Act, so you need to amend it. So it was sent back to the DWP, who reviewed it, presented changes to Parliament that they would like Parliament to pass, and Parliament then indeed passed those laws to make this consistent with the Human Rights Act. The one everyone's going to go for, however, is the Anti-Terrorism, Crime and Security Act, and this is a very, very straightforward one that I think we've discussed at great length. The Human Rights Act said you can't lock up people without trial. The Anti-Terrorism, Crime and Security Act said under certain circumstances you can. Now, those are not consistent. And the courts reviewed the legislation and they said the circumstances that would permit you to do this have simply not been met. Therefore, the Anti-Terrorism, Crime and Security Act is not compatible with the Human Rights Act. Parliament, you have to go back and think again. And indeed, that's what they did. Perhaps the simplest one, however, is the Factatemi case. You probably know all about this. This is the Merchant Shipping Act, which says British fish with British fishermen. Then we in the UK passed, that's what we passed. That is incompatible with the EU rules, which say EU fish for EU fishermen. They were challenged in court, and of course, it's obvious, I think, when you look at it from this direction, that the two laws were incompatible, as EU law is subordinate to EU law by virtue of the European Communities Act 1972. The UK law had to give way. And there we go. So again, the courts here are not trying to usurp legal sovereignty from Parliament. They're simply trying to make sure that Parliament's law is the best it can be. And if Parliament has asked the courts, to check the compliance of its legislation with EU legislation, then the courts here are doing their job. If Parliament has made sure or has undertaken to abide by the Human Rights Act, and it is said to the courts, to call it out when it passes law that is incompatible with the Human Rights Act, then when the courts do that, they're just doing the job that Parliament asked them to do, which is to be the custodians or the guardians of the will of Parliament as expressed in statute law. So we talked about the politicisation of the judiciary. Now we seek to avoid that. Because, as I said, this is the whole thing about positive and normative statements. And if you haven't looked at SCOTUS yet, if you haven't looked at the United States Supreme Court yet, you will soon know exactly what I am talking about, because it is the Supreme Court of the United States who decides whether or not people can have abortions or carry guns or take drugs or vote. These are normative these are normative, value-based judgments, and the American system has essentially shunted the final decision on these subjects to unelected judges. Hence judicial rule, hence rule by robes. You can check out, I got millions of videos on this. Please do have a look at them and send me your questions. In order to avoid looking political, what we've got is the judges giving the benefit of the doubt to the elected representatives. Now, it's not about going soft on them. It's about saying, look, if there are two ways of approaching this problem, then we have to go with the way that upholds the law, because the law was created for us by democratic institutions. So only about 10% of judicial review cases are heard, and of those 10%, only about 10% actually find against the government, or in other words, 1% of the total number of judicial review files are received are eventually go against the government. So, 100 cases of judicial review received, one of those will go against the government. However, that's the one that all the ministers moan about, and that's why Charles Clarke was earlier going on saying that he thought that some form of dialogue with the senior judiciary would be beneficial because of 1% of cases going against the government. What an absolute liability. Okay. These resources, sadly, are redundant because Storify is dead, and because I'm a twit, I forgot to take those across. However, I will link off to the Kilmuir rules, and I will link off to a couple of other things in the comments section. In the notes, in the footnotes, according to this. This is a complicated subject. If you need some help on this, do ping me a message. If you would like a tutorial on this, my rates are reassuringly expensive. So do please come to me through the comments section, and we can happily set up a tutorial on Skype if that's the sort of thing you'd like to do. This is one of my favorite subjects. I love talking about it. I hope you've enjoyed this. Do come to me with your questions. And good luck with this particular topic. It's an absolute humdinger. It's complicated, but if it was easy, then where's the fun in that, eh? That didn't quite work. Sometimes you just can't make a dramatic exit. Do quite like my theme music though. I'm going to let this play out. Enjoy and happy studies. Questions in the comment section. You know where to find me.